Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
Today we're going to respond to some viewer questions. First, I wanted to let everybody know that we get your questions, and sometimes it's kind of hard to fit them into one program, short of giving yes or no answers only, and that probably wouldn't be fully responsive as it should be. Today, Bob, let's talk about, excuse me, new laws regarding marijuana, civil compromise in criminal law cases, and children and the family law courts.
That sounds good. It's very timely subjects with some changes that we just had.
Absolutely. First of all, the question was, is there a conflict between state and federal laws regarding marijuana?
Oh, yes. The answer is oh, yes. Marijuana is illegal under federal law under the Controlled Substances Act of CSA Title 21 U.S.C. Section 811.
In case anybody is interested.
In case anybody wants to
Right.
look that up. But the federal law does not recognize the difference between medical and recreational use. So the distinction California has made between medical and recreational doesn't apply. As the federal government's concerned, it's basically all recreational. They don't recognize the medical aspect at all.
Well, maybe not quite, all right? Certainly under federal law, marijuana is treated like every other drug, such as cocaine or heroin. There is, not that I know of, any medical use for either of those two drugs. And in the federal's eyes, there's no medical use for marijuana either. But I'll tell you kind of a way around that, as it were, in a minute. Under federal law, marijuana is classified as a Schedule 1 drug. There's Schedules 1 through 4. But Schedule 1 means that the federal government views marijuana as highly addictive and having no medical value, which is kind of interesting. Now, as most Californians know, Proposition 19 did not pass, which would have legalized marijuana in the state of California. That would have been very interesting to see how the federal government in California dealt with that. But however, just prior to election on October 1st, Governor Schwarzenegger signed Assembly Bill 1449, which decriminalized the possession of marijuana. So now it's only a $100 infraction fine.
It's a big difference.
That's true, which means it doesn't go under your criminal record and may impact certainly some professionals that had to report to their licensing agency if they are arrested or convicted of a misdemeanor. This does not appear to apply to them.
That's a very interesting thing because it's going to save a lot of professional licenses.
We'll see how the licensing agencies deal with that.
Because the agency might not relieve them of the responsibility of the infraction if it's a certain type.
Because it's drug-related conviction.
Right.
But now it's a $100 fine, but it also means that people who are arrested for possession of marijuana are not entitled to certain benefits that they would have if they were charged with a misdemeanor. In other words, no court-appointed attorney. They cannot have a jury trial, only a court trial. So there is an impact to the individual, and certainly it will have an impact on the courts.
It's going to have some negative aspects if you have a certain set of facts and some positive if you have the other. But you're right about the courts. Be doing less marijuana cases.
Exactly. They'll be handled much like we see speeding tickets handled today. So.
Well, the basis of the Assembly bill was that it will save money and no longer be a need for the judges and attorneys appointed to each and every case, like misdemeanors in possession cases of controlled substances.
That's correct. And the impact is such that during the last year, there were approximately 50,000 arrests in the state of California for marijuana. And over the last decade, about 500,000 arrests for marijuana. That's a lot.
Yeah, the laws regarding new dispensaries, they're still under the purview of individual cities and counties, as I understand it.
That's correct.
They always have been, right?
That's right. And if people follow the news, see Sacramento, Stockton, they're going through some law changes, and most rural counties just won't allow them in. Their government pretty much can set up standards where they're just not going to come in, which means that people have to travel to more urban areas to get their medical marijuana. But that's up to the rural government. And if people don't speak out, you're not going to get a dispensary in your rural area.
Well, that's kind of interesting because we see these dispensaries pop up in where there's greater population, but there's local city governments as opposed to board of supervisors. And I'm just wondering if there's some connection there between the governing types of governing agencies that are allowing these.
We can always speculate.
Yeah.
Now, there is a way around it, okay?
Okay.
And that there's a prescribed medication, that is?
Marinol.
Yeah.
And why is Marinol different? Tell me.
Well, first of all, Marinol is controlled by the Food and Drug Administration, which marijuana is not because it's illegal. And it has many of the same elements as marijuana. Specifically, it's 100% synthetic tetrahydrocannabinol, THC.
That's the element. Go ahead.
That's,
I don't want to steal it.
as marijuana users would say, that's the good stuff in marijuana that adds to their relief of their pains or whatever they happen to be. And that's what we call the psychoactive psychoactive ingredient in marijuana. And that is actually protected under the Americans with Disabilities Act. Okay, now we're talking about Marinol, we're not talking about marijuana. But because it's administered through the Food and Drug Administration, doctors can prescribe Marinol. Doctors cannot prescribe marijuana. They can only recommend that a patient uses it. If they were to try to prescribe it, they'd lose their license because that's controlled through the federal government, because doctors can write prescriptions. Prescriptions are controlled by the federal government, or the doctor's ability to write a prescription. So that's why you only get recommendations for marijuana, but Marinol is under the Food and Drug Administration. They can issue an actual prescription for it.
Hey, that's kind of an interesting thing, and the thing I find kind of amazing is, because I had a client once that was taking Marinol, and the interesting, if you're taking Marinol, you can have a DUI under that, just as easy if you were smoking marijuana. But the price of Marinol is quite high, as I recall, and quite more expensive than marijuana.
That I can't tell you, because I frankly don't know. But what you spoke of DUIs, what people need to understand is you can be arrested for a DUI even if you're on a prescription drug, irrespective of what that drug is. If it affects your central nervous system, it affects your ability to drive, you can be arrested, no alcohol in your system. But some of the drugs today are derived from opium that's been refined down, whether it's morphine or some of the other stuff. Many of the drugs.
They're referred to as opiate derivatives.
That's correct. But you can be arrested without alcohol in your system for any prescription medication, again, if it's affecting your ability to drive.
And that's at the officer's discretion, pretty much.
That's correct. The next question was kind of an interesting one that I was surprised that a viewer was even aware of it. It relates to what is referred to as civil compromise under criminal law.
Well, the civil compromise under the law, or under, I'm getting into a tongue twister here. The civil compromise in criminal law means that the parties have worked out an agreement which either stops a civil action from being filed or results in the dismissal of a civil case. I'm talking about in civil law now,
Right.
but I'm blending it, trying to blend it into the criminal law. How is a civil compromise that we have in civil law. Basically, we do this all the time in personal injury cases and stuff. But how does it treated in criminal? How does it come into effect here?
Well, let's talk about the civil aspect for a little
Okay.
bit. Obviously, if you're representing a party and I'm representing a party and there's whatever the injury is, what's the car accident or whatever, the compromise is I'll give you some money if you won't file a lawsuit, or I'll give you some money and you dismiss the lawsuit. It's the parties that are coming to the agreement, and most often the courts are just kind of carte blanche, just giving their blessing to it because it's been compromised. It does differ, however, if the victim party is a minor.
True, or somebody on a conservatorship or something like
Right.
that, incapacitated.
But for the most part, it's in control of the parties rather than the court.
True.
Criminal law is completely different. In a lot of ways, one might say that there's really no civil compromise in criminal law, at least not like civil law. The court in a criminal law context has more power to determine whether a case should be compromised, and the law also limits the types of cases where there can be a civil compromise. They're just, which I'll get to in a second.
We don't see this a whole lot.
Once in a great while. I've actually done it with some clients, but again, we don't see it that often. In criminal law, if the victim or the perpetrator reach some type of agreement, the DA can still file charges. Even if the victim says, I don't want this, I don't want charges filed, the discretion is with the district attorney's office to file charges or not to file charges. So nobody, not even the court, can control the DA
That's the
filing or
same
not
as a
filing.
domestic violence case.
We see that often in domestic violence cases. Now, it's surprising that civil compromise in California has been around since 1872. And I didn't realize that until I'd actually done a little research on it. And at that time, the courts allowed civil compromise in misdemeanor cases as long as the criminal defendant adequately compensated the injured person for all of the costs incurred. And that was finally put within California statutes. And for those that like to do a little homework, there are Penal Code sections 1377 through 1379. It is codified in California.
Well, there are some exceptions to that.
But there are some exceptions, correct. What are they?
By or upon an officer of justice, law enforcement is an example, while in the execution of their duties. Riot, of course, that's a little bit vague and ambiguous, but
Right.
it's there. Where there is intent to commit a felony in violation of any domestic court order. By or upon any family household member.
There's your domestic violence again.
It's just kind of double up
Right.
there. Elder abuse and certain crimes against children.
Right. Word be more appropriate would be if you tore down your neighbor's fence because you were mad at him, but you kissed and made up and decided it would be better to put it back up, pay for any damages, then we may have a civil compromise in the courts.
Well, I have
in the case,
I
excuse
have
me.
a kind of question about this. If this is in the statute and the parties come to a civil compromise, is the court and the DA bound by this? I mean, can the DA still file? I'm kind of curious about that.
Okay. Now this is under section 1378. The victim must actually go to court at any time before the trial and acknowledge that he or she's received full satisfaction for whatever the injury is, and the court may, in other words, the key word is discretionary, or discretion part of the court can order all proceedings stayed on the prosecution, and the defendant will be discharged. In other words, the case is over. But again, it's up to the court
Now, when
to
we
be able
say
to do that.
up to the court, we're kind of using terms of art, but what you're really saying is it's up to the judge, right?
Correct.
Okay.
For the most part, when we talk about court, we're talking about the judge, because the court is
Right.
arguably
But
the
I'm
judge.
thinking the DA is going to get, the district attorney is going to get to chime in on this a little bit too.
Certainly, they have a right to object, but the law doesn't say, with the concurrence or agreement of the prosecutor. It doesn't say that at all.
Interesting. So if the judge feels it's an equitable distribution, he can just order it.
He can order it to be done. It's the case is over, the victim's happy, case is at end. Again, it can't be any of those crimes that you named,
Right.
but if it's just a simple vandalism, for instance, that's not a problem. There's actually some certain statutes that I think around 1380 that deal with graffiti in San Francisco, specifically San Francisco, but there could be a civil compromise if there are certain things that are done, but it only applies in San Francisco.
There's a lot of things that only apply in San Francisco.
They're usually a test bed for many cases.
are.
So that's why perhaps that particular law in there is relating to San Francisco. They're testing a law in that area, and if it works out well, then they may expand it to other areas. Most of those have sunset clauses, and I didn't research that aspect, where the law actually disappears after a period of time unless it's extended. Now, when the court is listening to the victim and is thinking about and is prepared to order that the case has been civilly compromised, then the court has to actually state on the record what the reason for the compromise is. Now, it's very important that the court do that, and when I said about stopping the prosecution, once that court makes that order and finds the case civilly compromised, that's the same as jeopardy attaching. In other words, the person, the perpetrator, the defendant, cannot be charged for the same crime.
That's
against that.
double jeopardy.
That's right.
Yeah.
Of course, unless there's a new act, but then we have the double jeopardy rules kick in, which is very important. So that's another way of telling the DA that the court's made its decision. You can't go around it by trying to recharge it.
Is there any negative parts to a civil compromise of a criminal case?
In my research and the cases I've done, the short answer is no. There's no negative to it. The important thing is if the parties have reached an agreement, I will pay you money so you can repair that fence or whatever it is. The court will look to see that the money has been paid in full. The problem is if it's merely a promise to pay the money, it's merely a contract, the victim has not been fully satisfied, and the court should not allow that to go through as a civil compromise. If they do, then that would be a negative to it. But in my experience, whatever the damage is has to be completely satisfied, and essentially there's nothing else to do in the case.
The courts seem to have a tendency to really go overboard to protect the victim and make sure that, so to speak, justice has been done.
The court really has a dual purpose role, and that is exactly what you said. Not only protect the defendant's rights, but also protect the rights of the victim, the people of the state of California. So that's a lot of responsibility on a judge.
It is. Lastly, we have questions about children's rights in family law cases.
It's really a big question.
It's
and
large.
We're going to try to compact it as much as we possibly can. In short, children are not parties to a family law case. And as such, they don't have the same rights as a parent would have in a family law case. Now, there are some situations where the law does allow a child to become a party in a family law case, but in my experience, the courts don't particularly favor that happening. Because you can imagine 8, 9, 10-year-olds, assuming they had the money. Of course, the question is, where would that money come from, one parent or the other, et cetera. But to actually come into a case and have the same abilities and rights as the parents would in a case. It does happen, but it's not very often.
I'm thinking of child actors where the parents are getting a divorce and who's going to have custody of the kid. We've had some interesting cases. I won't go into the names of them, but I think we all know about them. And that has come about.
There are certain situations where the court could allow it. And the court really, my belief is, can say no. You can't join this as a party. However, that doesn't necessarily just throw the child out without further consideration, because part of the reason why we're there in the family law context is dealing with child issues.
Right, and those are custody and visitation and how the child is going to be implemented in the new family structure. Am I right about that?
That's correct.
Okay.
But They're not the same as the parents.
They're not actual parties.
They're not actual parties. Now, are situations where the court can actually appoint an attorney for the child, but that doesn't mean that the child's going to be able to come in court, sit next to their attorney, be able to speak to the parties, the mother, the father, or the court directly. The attorney is their voice. The children, in most instances, are not even allowed in the courtroom.
Well, does the court allow them to testify or take testimony from them at some point if they have, a concern about the child's interest?
I have seen situations where the court has allowed a child to speak, but in my experience, it is outside of the courtroom, like in the judge's chambers, where the judge can sit down with the child, speak in a less, I won't say professional, that's not a good choice, in a more of a level that the child can understand, to try to get a better feel for what the child really wants,
User-friendly.
so to speak. But that's kind of gone by the wayside now that we have attorneys being appointed for children, because the attorney's purpose is to tell the court what the child wants and what they believe is in the best interest of the child. So the child now has a voice.
I just have a question. Go ahead, and then I'll finish. I'll come up with the question I have after you finish. I'm sorry. You're talking about the voice.
Well, again, I said that they have a voice. Now, one of the things I want to say is that, well, in many counties, appointment of an attorney for the child is at the court cost. The court's not bound by that. The court can't order that the parties pay for the cost of the child's attorney. That does happen from time to time, particularly if you've got a parent that is taking a less than credible role in the court case. In other words, they're the ones who are the pain in the tush. If they're causing problems that are needless, there is a term for it that we see in the law, frivolous motions, etc. The court can actually make that party pay for the child's attorney.
It's kind of interesting. These lawyers that are appointed to represent children in family law cases involving custody and other matters, are these special attorneys? Do they have some kind of special qualifications?
There's a qualification process, and I didn't research it before coming here today, but you just can't take somebody straight out of law school and say, now you're going to be representing children. They've got to have a certain level of experience. I know when I've done some of this in the past, I've taken special classes, but yes, there are certain requirements. It's all statutory. In other words, it's in the law somewhere saying that you've got to do, these are what your duties are, and somewhere in there I think is the educational component of it as well. But for the most part, most of them have practiced family law before. They have a good idea of what is going on in court. They just don't pick them out of the blue and say, this is your job now.
Hopefully not. I would not like the court to pull me out of the blue and give me something I didn't know anything of. Is there a constitutional issue that arises if children are not allowed to have a voice in this whole process?
The short answer is yes. There have been groups that have raised the constitutional issues on behalf of children, but I'm not aware of any appellate court at this point that has indicated that the child is entitled to the due process rights, same as the parents, in a family law case. Now, certainly in other types of cases, the court does address the constitutional rights of a child, but I've not seen it within the family law context. And certainly that is an issue that remains today. Some people feel that some children ought to be allowed in the courtroom, be able to exercise their rights, but thus far, I have not seen it. The legislature certainly hasn't acted on it.
Well, is the basis of appointing an attorney, is that come somewhere out of our Constitution, or is that statutory by the legislature?
It's statutory. No. Now, in looking at the children's attorney, they really have a lot of authority out there. They can not only look at the family law file, they can interview the child, they can go to the child's school, they can talk to the child's doctor, the child's psychologist. They can look at any record that they feel is important. And even things that you wouldn't think that they could do. They can go talk to the child care provider, they can go talk to neighbors. they can do a lot. And they don't have to tell you what they're doing or when they're doing it. But that's part of their job, is to get as much information regarding the child that will be beneficial to the court so the court can make the best decision possible. In some situations, the court will actually order that the attorney make a written statement or written report to the court to consider before the court makes an order that is to be in the best interest of the child. Now, most often, that doesn't happen,
The written report.
the written report. But, and in extreme cases, the child's attorney can also request that there be an independent psychological or physical examination of the child. But again, that part is pretty rare, but there are instances certainly when that can happen.
It seems to me, because I have on occasion, when I was in the courthouse for other matters, sat in and caught some of these hearings, in other words, watched out of just interest. And it seemed to me that the judge was giving quite a bit of deference and importance to what the attorney for the child had to say.
The idea is that the attorney for the child is going to be in a better position and a more neutral position to advise the court. Many times what will happen is that the child's attorney will meet with the child and the mother, then meet with the child and the father, and oftentimes meet with the child alone, trying to get the best perspective. In other words, is there influence from one parent or the other? Is the child influenced by the fact that one parent or the other is present? So there's a lot that goes into it. And for the most part, I really do think that the attorney is trying to give the judge the best information possible so that the judge can make an appropriate decision. Now, I don't always agree with that decision, needless to say. I don't think all attorneys do. 50% of the parties, there's only two, are not going to agree with what the child's attorney says, but the judges do follow very closely what the child's attorney's recommendation is.
You know, Steve, it really seems that these family law cases involving children are fairly involved, and that in many cases, an attorney, the main role there is what's best for the children and to protect their rights.
To a degree, they're protecting their rights, and we're here referring to constitutional rights. But the bottom line for that family law or child's attorney is to protect the best interests of the child. And many times, that best interest of the child is in opposition to what the child wants. The child wants to be with one particular parent, is very adamant about that. But that particular parent may have extensive legal problems, in and out of court system, can't get away from using alcohol. They spend most of their time drunk or under the influence of alcohol. They may be homeless. So the court really has to look at the best interests of what the child is.
Yes. It's interesting. Sometimes I see a crossover between the family law court and the juvenile proceedings.
Unfortunately, there's often juvenile dependency, family law, and criminal cases all going on at the same time, involving the same parents and children. So, thank you for joining us today on You and the Law.